Okay, hi, my name is Jenna Barnhouse,
And I'm Damian Allione.
and we are doing the Wallace versus Jaffree case. I am going to be covering the main points of the case. Damian will do the parties. I will also be covering the facts. He will be doing
Legal issues related to religious freedom.
and he'll also be talking about the three-prong test, and I will be discussing whether or not we agree or disagree with the outcome of the case. Okay, so the main points of the case that we're going to be discussing is that the case occurred in 1984 and it ended in 1985. It was basically an Alabama law authorizing a period of silence for meditation or voluntary prayer. And it just kind of talked about how prayer in the public schools and whether or not that affects the Establishment Clause. And the Establishment Clause is in the First Amendment of the Constitution. We'll be talking a little bit about that. And we'll also be talking about the specific wording of voluntary prayer.
So for the parties, Ishmael Jaffree was the father of two students in the Mobile County public school system, and he sued the school for religious purpose because they were doing voluntary prayer and they were doing meditation for 1 minute. And the reason he sued also is because his son was getting bullied by his peers for not participating in those time periods for meditation and voluntary prayer. And the governor during this time for Alabama was George Wallace, and he has been dealing with government for over 40 plus years, and he did 4 terms for being the Alabama governor, and he allowed the state statute of meditation or voluntary prayer to happen.
Okay, so some of the facts of the case, and he was talking a little bit about it, but Jaffree basically felt that his two children were being indoctrinated by the school system to believe in a certain faith more than other faiths specifically. And like he said, one of his children was supposedly getting bullied by other kids for not choosing to participate in the prayer time. They took it to the district court, which is the state court level, and they found it constitutional. They didn't see anything wrong with it, but as we have discussed in class, that can then go to the Court of Appeals. So it went to the Court of Appeals, and they reversed this because the statute, and this is in quotes, intended to convey a message of state approval of prayer in the public schools, and was a clear violation of the First Amendment of the Constitution. So those are kind of some of the basic facts of the case.
Next, we'll be dealing with legal issues related to religious freedom. And the First Amendment of the Constitution prevents the government from making laws that really regulate and establish an establishment of religion, or that prohibit the free exercise of religion. So in this case, the judges really focused on 3 laws that the Alabama made as state laws concerning freedom of religion. And it was created the minute-long silence for meditation or voluntary prayer, and authorized teachers to recite a prayer for students that were willing to do so. Now, dealing with the legal issues concerning those laws was that it violates the Establishment Clause, because the Establishment Clause prohibits, in quotes, prohibits the government from making any law respecting an establishment of government. And the term voluntary prayer is very broad, because a lot of people can take it a lot of different ways, and it was thought to be respecting a specific establishment of religion because they were as kids in elementary, when you hear prayer, you think of Jesus and you think of God and you think of Christianity instead of thinking of other religions. So they really use, Jaffree and his team really use voluntary prayer as in that way, as prayer as only relating to one religion instead of like Buddhism and the Islamic cultures and everything such as that. And now we'll be talking about the three-prong test that they also use to really use as a
Like a guideline.
Guideline, and it's called the three-prong test. And it's so in 1971, for example, from Lemon versus Kurtzman, the Supreme Court set forth a three-prong inquiry known as the Lemon test, which are a law must satisfy to be valid under that clause. It must have a secular legislative purpose. Its primary effect must either advance nor inhibit religion, and the third one, it must not foster excessive government entanglement with religion. So this case did not pass the three-prong test mainly because of the last one, where it must not foster excessive government entanglement with religion. So really, the government got too much, and religion got too much to get like all tangled up with each other, and they try to combine it, which is never a good thing.
They try to advance a certain religion kind of above any other religion.
And also, the state statute fostered government entanglement with religion by implementing this law. It's kind of like church and state, where you have the state and you have the church, and you're trying to keep it separate now. So it's separation of church and state.
Okay, so do we agree or disagree? So Damian and I were kind of going back and forth about it, like saying, do we agree with this? Do we not agree with this?
Because you can take, really, there's an argument for both sides.
There is.
Where there is valid points, especially dealing with voluntary prayer. Because you can say voluntary prayer is you don't really have to do it. We're just saying you're allowed to if you want, and you don't have to if you don't want to. You will not get in trouble.
Right.
But I think you can also say on the other side, voluntary prayer, especially for elementary kids, when you say that and they see everybody else doing it, they will want to do it so they don't stick out and everything. And that's what exactly happened to Jaffree's son, or Jaffree's kid. He didn't do it and he got bullied. So now everybody's seen that. All the kids have seen that. And now they feel like they have to do it, especially when they're younger. When they're older, it's kind of a different.
When you're younger, you have more of a chance for that kind of indoctrination because you're young, like you're susceptible to anything. But as we were talking about it, we kind of had to step back and look at it solely at a legal standpoint. And we do agree that the law violated the Establishment Clause, and this is only because that it's in a public school. Obviously, if this were a private establishment, a private school, it would be a whole different issue, just like we attend PBA, and PBA is a private Christian college, so we're allowed to have chapel and prayer, and because it's a private institution. But when it's in the public arena, it's susceptible to the separation of church and state and that kind of stuff. And he kind of talked about this too, but the term voluntary prayer, that can be interpreted in many different ways. Prayer for a Christian is going to look way different for prayer than to a Jew or to a Buddhist, or because prayer can be implemented in many different kinds of religions. So the student didn't have to take it in a Christian standpoint, but a fact of the case is that the teachers were actively reciting the prayers with the children, and that kind of gave it more of that like Christianity, that Christianity implement, that Christianity zone, and it just didn't really recognize all of the other religions.
But there's two valid points for each side, but we just came to the conclusion that we overall agree that we can see why they got rid of the laws and marked it as unconstitutional. But we can see why the district court did mark it as constitutional.
We can see it as both, because voluntary, like, they weren't enforcing it. It wasn't anything that was like, oh, you have to do this, you have to do that. But like he said, when it's children, they're just gonna want to do what all the other kids are doing, and that's really kind of where the issue was. And if the meditation and voluntary prayer was all that the law consisted of, then we would maybe have a little bit of a different opinion. But the active recitation of the prayer from the teacher with the students has a Christianity implication and could be seen as indoctrination, which again violates the Establishment Clause and violates that First Amendment. So, and that's all we have. So thank you.
Thank you.